my children were taken from me, and they have denied all contact and communication for 108 days since they were taken. There's no order restricting communication, but they have denied such.
Your Honor, I filed a motion for contempt and a motion for psychological evaluation of the defendant, and we are asking that Ms. Hilliard be required to submit to psychological evaluation. This is a case, I don't know if you recall, but the mother moved to Tennessee.
Yeah, and I entered an order, and Mr. Towns found her.
She took the children to Tennessee
Yeah.
for a year and a half. He had no contact, didn't know where they were. We finally located them, had her served, scheduled the temporary hearing. She failed to appear at the temporary hearing, and the court entered an order giving custody of the children to Mr. Towns.
Yes.
Mr. Towns took physical possession of the children at the end of May of this year, and the children have been with the father since that time.
And Miss Anderson was also named guardian ad litem.
Right. After we got possession of the children, Ms. Hilliard hired Ms. Riedel, who filed a motion to vacate the order. We came to the court back in June for a hearing on the motion to vacate, which the court denied. And at that point in time is when you appointed Ms. Anderson as guardian ad litem.
Okay.
Okay, and so Ms. Anderson has gotten into the case since then. Since the children have been in the possession of my client, we voluntarily allowed some telephone contact with the mother. Those phone calls are extremely disturbing because the mother does everything in her power to alienate the children from the father. She tells the children all sorts of horrible things about the father. She talks all about this case to the children. The very first phone call, my client got possession of the children, I think on May 28th of this year. The very first phone call was on June 4th. The child starts the phone call by telling the mother that she misses her. The mother's response to that is to start telling the child about the court date, telling the child that she's sending the police over there to do a well check, and that all the child has to do is tell the police that they want to go home to her mother, and that that's all it'll take. So getting the child's hopes up that she can tell somebody she wants to go to mom's and she'll get to do that. She makes derogatory statements about the father, tells the child that the father's not a man. Any woman who would take a woman's baby ain't a man. She tells the child that he didn't know what he'd gotten himself into, that he's going to have to start coming to Tennessee and have supervised visits. She tells the child that the father is evil. The phone call lasts for, I don't know, 25, 30, 45 minutes, something like that. And at certain points in time during the conversation, the father comes to the child and says, hey, it's time to get off the phone, and also tries to get Julie, is the main child that this is going on with. He tries to get Julie to get off the phone and let the other child talk to Mama, okay? And Mama tells the child to tell Daddy he's lying, you haven't been on the phone that long, tells the child to defy the father, tell him you don't have to get off the phone, there's nothing in that court order that says I can't talk to these children, and just on and on and on. And then later in the phone conversations, when Dad comes in again and says, hey, it's time to get off the phone, you hear the child saying, no, I can talk all I want, you're lying, things like that. So the child's parroting what the mother has told the child to say. She talks derogatorily about the girlfriend of my client and tells her that she has no right to tell this child anything. The child tells the mother that she had gotten in trouble because she had bit the sibling's finger and that her dad had told her that he would spank her if she did that again. The mother tells the child he's not allowed to do that, that's illegal. I'm going to call the wall if he touches you. You tell me if he touches you, and just on and on and on. She goes on and on in the conversations at certain periods of time, and she knows that we're recording these calls, apparently, because in these conversations, she starts talking to me.
All right, well, all right, I got it. You're going on and on.
So-
You do have these recorded.
I have these recordings right here today, and
All right.
I would love for the court to listen to every one of these. It's
Well-
going to take some time because there's probably more than an hour's worth of conversation here. I could do bits and pieces, to show.
Have they been provided to Ms. Anderson?
Yes, they have been provided to Ms. Anderson.
Okay.
And I have transcripts of them too.
All right.
So this is the basis of why I feel a psychological evaluation is needed. Because this mother is doing everything in her power to influence, manipulate, and alienate these children, and specifically Julie.
So you're asking the court to hold her in contempt and do a psychological evaluation, is that correct?
I want a psychological evaluation on that. The contempt involves the
Payments and other things, I understand.
temporary order. You had ordered the mother to pay the father's attorney's fees of $5,000. Those have not been paid. Additionally, there was an order on appointing the guardian ad litem. The original order ordered her to pay $375 to Ms. Anderson. There was a second order, which was an amended order, which ordered $1,500 be paid. It's my understanding she's paid nothing to Ms. Anderson, and she has paid nothing on the father's attorney's fees. So we are asking that she be held in contempt on both of those issues.
I'm here today just as a mother to my baby girls. I object the phone conversation. That accuracy is not true. You can go over that.
But she says they're recorded.
Yes.
You mean I'm going to sit through this for an hour and what's going to be the point if it was recorded?
For accuracy, because I did not, what she stated, when Julie even answered the phone, I would redirect her. I'm here, I love you, just give us time. Julie's very aware of everything, so yes, I would tell her, we have this court date, everything's gonna be okay. I would always reassure her. Her stating that I would make derogatory remarks towards my ex or his girlfriend, they're irrelevant. My children were taken from me, and they have denied all contact and communication for 108 days since they were taken. There's no order restricting communication, but they have denied such. Yes, I'm sure on some of the occasion in the phone conversation, I'm enraged, I'm heartbroken. Those are my babies, and they're throwing all these false accusations as if I'm this monster. I'm a mother and grieving. They took my babies, and on the move, to get back to that, when I moved to Tennessee, he was very aware. He called and even stated, I gave him the county that they were in, the physician, the school. He is a grown adult. He could have went up there and did all this on his own and seen them. Even when I was in the same county, in Telfair County, he was nowhere. He would no show. I had to bring my babies to work because he would not show up to get them. At the beginning, when he was arrested, because I had to file the divorce and pay for it and all, I gave him visitation. I gave him every other weekend, spring break, summer, it's in that paper and all. He would not show up, and then when he slashed my tires and was arrested, the DA reached out to me and stated, do not have no contact with Robert Towns. I did so for my girls because it is in their best interest to have a father and have that, involvement. I would pack everything they needed, food, clothes, toys, for him just to not show. There were several incidents, I had to bring him to work with me because he wouldn't show. It got to the point, I said, okay, you can get him on Saturday morning, bring him back Sunday morning. And that worked for me because, that was less time, and so he wouldn't even show then. And that's when we were in Telfair County. I have never kept them from him. I have no desire to hurt my babies. They are my life. And for the last 108 days, they have not been here. I don't know what's going on. They've restricted me from educational, all information. I've contacted Telfair County Elementary. They won't give me information. I've sent written requests because he has put in a paper to deny me that information. I'm still their parent. I will always be their mother, and I will always be here. But the facts, I do object to that phone conversation. I do object to the date accuracy. None of that was correct. When I moved, I got that 3/25/25 was the Rule Nyson letter stating a temporary emergency. What the emergency was for, because I did not move and not tell him, that's false. I'm not sure. But 3/25, on 4/2, I went into labor. Early labor, it was horrific with my 5th child, who I exclusively breastfeed. I'm a stay-at-home mother because my babies are my life. And yes, that does account to why I can't come up with thousands of dollars right now. But today, yes, I can make that $1,500 payment or anything that's needed. I went into early labor. We stayed in the hospital a week. And yeah, of course, I wasn't that May 12th, appointment then totally went by me, and that's when I got all those letters on that date, and that needs to be looked at, because I didn't even have time to review all those affidavits and everything, because they literally came at my door on the court date. That's how I knew I missed it. I immediately called Riddle. It wasn't after my children were taken. It was immediately that day. She assured me that we would get a continuance or a motion to set aside. You made the ruling on May 16th. Obviously, that motion was never filed because my attorney was out of the country. And that's when I first got upset with her representation with me, because, that was horrible, because now you ruled, you took the babies and all. So immediately we got to that temporary hearing, and even my representation had all the dates wrong. He waited a week to even come get the children. That mattered to me, and so forth. But I have done nothing wrong. I have been a mother, first and foremost.
I signed it to give the guardian ad litem the discretion and the authority to resolve these visitation issues. Are you prepared today, Ms. Anderson, to give the court some sort of recommendation about how or under what circumstances to continue visitation, or you're not prepared to make any sort of recommendation on that today?
No, Your Honor.
Folks, the whole reason for the court appointing Ms. Anderson was to avoid exactly this.
Well, she kept putting...
Wait, hold on. Mm-hmm. Is for the court to have to run your lives for you. I have and continue to grant that authority to the guardian ad litem, so that, frankly, I don't have to do it. I will, don't get me wrong. You probably won't like it, but in any event, when Ms. Anderson reaches out to you, you might as well consider it to be the court, because that's her job. Ms. Hilliard, I don't want you to think I'm just sitting up here throwing a bunch of rocks at you, but it appears from what I've heard from Ms. Anderson that you're not cooperating sufficiently for the case to move. Now, Ms. Shook appears to be ready for the court to string you up. And, well, that's her job, okay? And Ms. Anderson's got a job to do as well. Now, since there's no court-ordered visitation, my expectation was by the time we got back together that there would be something moving. So I'm not going to order Mr. Towns to. I haven't yet ordered visitation. So all the contact has been completely voluntary by Mr. Towns up to this point. And I could go 1,000 different ways on this, but Ms. Hilliard, I'm going to put this burden on your shoulders and put this monkey on your back. If you want to get a visitation schedule in place, you're going to have to get with Ms. Anderson and get it straightened out. I'm not going to just do it. That's what Ms. Anderson is for, all right? So I am not going to order any mandatory visitation or contact. If you want to get a schedule, Ms. Hilliard, you're going to have to get with Ms. Anderson and get this matter resolved. Get her what she needs so that Ms. Anderson can report back to me with a recommendation. And if that's objected to by Ms. Shook, then we'll have a hearing. I'm going to take Ms. Anderson's a recommendation about the mental evaluation. I'll be fair, it'll be both sides, both parties. But the burden is going to be on you, Ms. Hilliard. If you want visitation and contact with your children, as you tell me that you do, then you're going to have to contact Ms. Anderson and get it straightened out. Ms. Anderson will contact me, and if we need to get back together, we'll get back together, and we can even do it in another county. It doesn't have to be here. I got 6 counties, and I'm in one or the other of them almost every day, so we'll get together. Don't worry about it. But not until you get Ms. Anderson what she needs so that she can make a recommendation. You understand that? Now, all these other issues of the funds and all that sort of stuff, I'm not going to get into that today. I'm going to reserve those, and let's just see how you do, Ms. Hilliard. Now, if you don't cooperate, then things will start moving quickly. You understand that, Ms. Hilliard?
And
You have any questions?
Is the case still open?
Oh, yeah, it's open. I mean, I'm not going to kneecap you, Ms. Hilliard. I mean, not today, but as long as you cooperate with Ms. Anderson, then we'll get this thing moving and get some sort of schedule in place till we get a final resolution of the case. We're just spinning our wheels. We're not getting anywhere.
Well, I mean, under the home state law, us being residents.
Under the what?
The home state law.
Home state law. I have no idea what you're talking about.
I filed it in one of those motions. Let me see. Just before he filed, we was residents of Tennessee for over 6 months.
Well,
And I was really.
Look, Ms. Hilliard, you may be exactly right about all that, but that's not before me today. And until you hear from me, otherwise, you're going to have to deal with Ms. Anderson. You've gotten my full attention now, Ms. Hilliard, so I'm going to expect things to happen to get this visitation going so we can move to a final hearing. I mean, this case is not old. I don't want anybody to think I'm particularly fussing. It's not old, but I want to get it moving. I don't want to wait another 3 months and nothing happened.